Viewers, welcome back to the show. Tonight's topic of discussion is intentional torts. That is, people being assaulted in pubs, clubs, walking home from work, those sorts of incidents. The first case I want to go to, you guys, is Mulberry, Triangle and Ansell. Who wants to give me the facts?
Tony, this is a case which originally arose in South Australia and concerns a fellow who was working in the video shop at the Mulberry Triangle shopping centre, a bit like your average shopping centre, lots of specialty shops.
It's more like a Bermuda Triangle, this case.
That's right. Anyhow, this fellow was, he locked up the shop, it closed at about 10 o'clock. He walked from the shop to the car park to drive home, and the lights in the car park had been turned off. By that stage, they were on an automatic timer, and so they were turned off at or slightly after 10 o'clock. And by the time he got to the car park, it was dark, and unfortunately he was set upon by 3 people armed with baseball bats, and he was severely injured in an incident, a criminal incident. So it's very sad facts, and essentially this case made it all the way to the High Court because the plaintiff sued the shopping centre for the criminal acts of the third party.
Nuncio, I'm surprised that the injured party didn't sue the employer as well.
Look, Tony, there's 2 reasons for not doing that. One is that in South Australia, there's no common law against your employer. So unlike Victoria...
So that's to get around the law.
That's right. And secondly, on the facts of the case, the main tortfeasor or wrongdoer, as they say, would have been the shopping centre anyway. So I don't think it was as prevalent.
In the first instance, what happened, Alice?
In the first instance, Tony, actually the plaintiff got up. The District Court of South Australia found that the plaintiff should receive compensation from the shopping centre as they had not had a safe premises for him, and essentially that they should guard against criminal acts of third party. But of course the matter was appealed because the shopping centre felt that that was a very heavy burden to carry.
Well, he just won on inadequate lighting.
The shopping centre were put on notice that they were worried about the lighting, they were worried about security.
Well, you got around the foreseeability of risk argument by the fact that they'll put on notice.
Yeah.
That's right, and on its face, Tony, this would have seemed like a very strong case because the shopping centre was on notice and he'd suffered injury as a result of the exact thing he said was the issue.
High Court said there was no duty for the shopping centre to be responsible for the acts of a third party or a criminal third party action. And look, I can understand that, but at the same time, when the shopping centre had sort of knowledge and notice of potential security issue, it probably doesn't sit as comfortably with me as some other decisions.
And Tony, I think it's also important to note 5 judges of the High Court heard this case. 4 judges found that the plaintiff shouldn't get any compensation, but 1 judge delivered what you might say was a blistering dissent, saying that the shopping centre should have been liable. The court, generally speaking, was very preoccupied with whether or not you can extend a duty of care to almost a random act by people who have nothing to do with the shopping centre. But as the dissenting judge, that's the disagreeing judge, pointed out in the judgment on this case, it would have cost the shopping centre little or nothing to keep just to change the timer to 10:30, for example, keeping the lights on.
Just on that point, are there circumstances where an injured party will be compensated?
Yeah, look, the High Court did make some exceptions and said that under special circumstances, they are responsible for the actions of a third party, and that is like employer, employee, school teacher and pupil.
Well, the plaintiff would have won in Victoria.
Yeah.
Because he would have sued the employer.
That's right.
Exactly right.
Correct?
Yep.
So bear that in mind, viewers. Now, is there anything else to come out of this case?
Generally speaking, Tony, it's sparked a raft of case law dealing with intentional torts, and the High Court did mention in its judgment that there could be certain circumstances where they will expect an occupier of premises to be responsible for the actions of third parties, and that's where we get Adil's Palace from.
Okay, now we're on this case of Adil's Palace. Adil's Palace and Mubarak, this happened in New South Wales. What are the facts of this case?
Well, it was a New Year's Eve function at a restaurant, but I think there was about 300 odd people there on that night. Scuffle between 2 ladies, and then I think a few other people got involved in it. One of the males who was hit or struck by somebody took offence to what happened, went home, got his gun.
Before he left, he said, "I'm coming back to get you."
Yeah, he said that. Got his gun, came back, went in, shot an innocent patron who's just trying to run away from him because he was scared obviously of a gun approaching. But then went to the person that struck him, and I think shot him in the stomach. I think it was.
That's right, in the stomach.
Shot in the stomach, and now we have a case.
Did they win?
That's right.
Did the people that get shot win?
No, Tony, they didn't, not in the High Court. But at first instance, though, within the District Court of New South Wales and also the Court of Appeal, the plaintiffs got up because the main reason being that the plaintiffs' main argument was that the restaurant did not have enough security, and the Supreme Court of New South Wales and also the District Court found that that was a fair enough argument, that there was, given that it was a 300-seat capacity restaurant, there was not enough security, and also this fellow, it was a volatile situation, it's New Year's Eve, lots of people pretty excited and all those sorts of things. But the High Court found that it was such a random and volatile act that the restaurant couldn't be expected to extend that far even if they did have good security. So they really got off on a technicality in this case.
Isn't it a case that the court, in simple terms, said you can't possibly guard against someone that comes in with a weapon?
Yeah.
That is a gun.
Yeah, look, I think they thought a gun. When you bring a gun into a premises, you've lost all sense of reality, and that no security could have stopped that. But I think it was a good, even though the plaintiff lost, it was a good decision because it shifted it from Modbury. Now there is a duty, and if you can prove that the breach has caused the damage, then you can get over it. So even though they lost, it was a good decision in the end.
What is interesting about these cases is that even though Adil's Palace has shifted the law a bit, Nonce, you also got things like the Wrongs Act you've got to look at these days, the factors under the Wrongs Act, and also the Liquor Licensing Act, which may impose liability on the premises like Adil's Palace and also Modbury Triangle. So they're highly relevant.
Look, if you were running a case, you've got a lot of causes of action under different pieces of legislation. You've got just common law negligence, you've got the Wrongs Act, you've got Liquor Reform Act. There's a lot there that the plaintiff can use to try and succeed in a case, which is good.
The responsible service of alcohol is pretty significant, isn't it?
Oh, look, there's a big emphasis on it now in pubs, generally speaking. You can't get a job in a bar without a responsible service of alcohol certificate. So there is heavy duties imposed upon occupiers.
Okay, we've got to go to a break, and after the break we're going to look at this responsible service of alcohol and this case of Scott, which deals with this issue. So viewers, please stay tuned.